for legal legals exclusively. Prepared liquidation amended Polish law provisions, Bankruptcy Law, Part 2. Article 56d. Approval of the terms of sale. 1. When granting the application, the court in the decision on the declaration of bankruptcy approves the terms of sale by indicating at least the price and the acquirer of the assets subject to the sale referred to in this section. The court may also, in its decision, invoke the terms of sale stipulated in the draft agreement. 2. The debtor and the applicant submitting an application for approval of the terms of sale may appeal against a decision dismissing the application for approval of the terms of sale, and any debtor and creditor may appeal against a decision granting such application. The appeal may be filed within 2 weeks of the day of announcement in the register. 3. The security deposit paid by the acquirer indicated in the application for approval of the terms of sale, which was not granted by the court, is reimbursed within 2 weeks from the date the decision on the declaration of bankruptcy and approval of the terms of sale becomes final and non-appealable to the bank account indicated by the acquirer, unless the acquirer made an application for the reimbursement of the security deposit earlier. The reimbursement of the security deposit at the acquirer's application results in the application for the approval of the terms of sale not being processed for the benefit of this particular acquirer. The security deposit paid by the acquirer indicated in the application for approval of the terms of sale, which was granted by the court, is credited towards the price and is promptly transferred from the court's deposit account to the bankruptcy estate. 4. The security deposit paid by the acquirer is also reimbursed when the decision on the declaration of bankruptcy and dismissal of the application for the approval of the terms of sale becomes final and non-appealable, or when the court decision on the return of the application for approval of the terms of sale or the decision on its rejection or discontinuation of proceedings concerning the application for approval of the terms of sale becomes final and non-appealable. Article 56e. Conclusion of the sale agreement. 1. The bankruptcy trustee concludes an agreement of sale on the terms set out in the court's decision on approval of the terms of sale no later than within 30 days of the day on which the decision is declared final and non-appealable, unless the terms of the agreement approved by the court stipulated a different time limit. The bankruptcy trustee is notified of the fact that the decision of approval of the terms of sale has become final and non-appealable by means of direct remote communication, in particular by way of telephone, fax, or email. 2. The conclusion of the agreement of sale may take place solely after the acquirer has paid the full price to the bankruptcy estate or after the price previously paid to the deposit has been released to the bankruptcy trustee. 2a. If the agreement of sale is not concluded owing to the acquirer's fault, then the bankruptcy trustee retains the security deposit. 3. The provisions of Article 313, Article 314, and Article 317 apply to the effects of the sale made pursuant to the provisions of this section. Article 56f. Release of the enterprise to the acquirer. 1. If a proof of payment of the full price into the court's deposit account has been appended to the application, the release of the object of sale to the acquirer happens promptly upon the issuance of the decision on the declaration of bankruptcy. 1a. The provision of paragraph 1 applies respectively if the full price has been paid to the court's deposits account in the course of the proceedings concerning the declaration of bankruptcy or upon the issuance of the decision on the declaration of bankruptcy. 2. The object of sale is released into the acquirer's hands with the participation of the bankruptcy trustee. The provision of Article 174 applies respectively. 3. Until the decision on approval of the terms of sale and conclusion of the agreement of sale becomes final and non-appealable, the acquirer manages the acquired assets within the scope of ordinary management at its own risk and responsibility. 4. When setting aside a decision on approval of the terms of sale, the court obliges the acquirer to return the object of sale into the bankruptcy trustee's or the debtor's hands. The decision constitutes an enforcement title against the acquirer. Article 56G. The release of the price from the deposit. 1. Once the decision on approval of the terms of sale has become final and unappealable, the court ex officio or upon the bankruptcy trustee's application will decide to release to the bankruptcy trustee the deposited price. 2. In the events different than the ones indicated in paragraph 1, the court rules to release the price from the deposit upon the acquirer's application within 30 days of the day on which the enterprise was released to the trustee or to the debtor. The bankruptcy trustee or the debtor may apply for the price to be kept in the deposit for 2 consecutive weeks, required to file an application to grant security for any court action for damages, according to general provisions. Upon the lapse of this time limit, the court will promptly decide to release the price from the deposit unless an application for the grant of security has been filed. 3. A court with a single judge rules in respect of a decision to release the price from the deposit in situations indicated in paragraph 1 and 2. Article 56H. The change of the decision on approval of the terms of sale. The bankruptcy trustee or the acquirer may, within the time limit set for concluding the agreement of sale, file with the court an application requesting that the decision approving the terms of sale be set aside or changed if, following the issuance of the decision, the circumstances having a significant influence on the value of the asset constituent subject to sale have changed or have been disclosed. The bankruptcy trustee and the acquirer as well may appeal against the decision granting this application. The provisions of Articles 56A to 56G apply respectively. Article 313. Effects of sale made in bankruptcy proceedings. 1. Sale made in bankruptcy proceedings has the effect of enforcement sale. The acquirer of the constituents of the bankruptcy estate is not liable for the tax liabilities of the bankrupt, including also the liabilities arising following the declaration of bankruptcy. 2. Sale of real property causes the expiry of the rights as well as personal rights and claims disclosed by way of an entry in the land and mortgage book or undisclosed in this manner, but notified to the judge commissioner within the time limit indicated in Article 51, paragraph 1, subparagraph 5. In place of the right which expired, the entitled subject acquires the right to satisfy the value of such expired right with the price obtained from the encumbered real property. Said effect arises upon the conclusion of the sale agreement. The basis to delete the rights which expired as a result of the sale and the final and unappealable distribution plan of the sum obtained from the sale of the encumbered real property. The sale agreement of real property constitutes a basis to delete the mortgage entry from the land and mortgage register.